because I sit in a courtroom and on the video chat, and I see people, man, if you don't pay this amount in a certain amount of days, you're going to jail. If you don't, that's what it says to everybody. I don't care what's your reason of not being able to pay. If you ain't got like your affidavits put together, if you ain't got your paperwork turned in saying, hey, this is what I'm standing on, then you go get stepped on. Like I ain't got a dub yet, but I ain't been put in a position where it's like that I've been put in before. Like, damn, if I don't come up with this money, I'm going to jail. If I don't come up with this money, my license wouldn't. I'm not gonna get them back. That motion to vacate, that understanding, it done changed my life. I ain't go in that short period of time.
Greg, let me ask you something. So, if legally speaking, and constitutional Bill of Rights says that we shouldn't be, a man or a woman shouldn't be going to jail because of alleged debt. But nevertheless, those lawyers slash hearing officers, they exercise contempt for compliance. I'm gonna lock you up. Then you're gonna come back. It's almost like, when you're doing, when you torture somebody. So so you torture them, and then enough for them, to either comply or continue, to inflict pain to them.
Well, so let's do this. That goes back to that same language that you're using that comes out of some of that stuff that Will just said to stay away from.
Mm-hmm.
I would say this: you're talking about peonage and you're talking about imprisonment for debt, and that could be considered unconstitutional. But I kept telling you it's not a debt, it's an obligation, and what they're going to say is you willfully disregarded the court's order. And in many cases, people do not raise affirmative defenses to their contempt cases. And I can't give you legal advice, but again, I tell people that wording, when people start using certain words, I cringe, because I understand what the Reaper will say it to me. Greg, there's going to be resistance, and they will use brute force if they have to. And he may enjoy watching you get your head kicked in. I'm just telling you, I think that there are other ways for people to get remedy. I didn't go through those things.
There's case law with what he's saying. Instead of using that the perspective of like the man versus this, I forget, you gave me a case law like Gregory versus something where like they have to prove, they got to prove it. Like if you're working and you pay this amount, they got to give you the date that you're working.
Hey,
the amount that you paid. Oh, thank you for your services, Will.
Thank you, Will.
Thank you, Will.
Hey, when you understand that your case is either administrative or judicial, judicial doesn't enforce what your administrative order enforces. So we just have to understand the difference in the two. And once you differentiate the two, you're able to focus in on what your case is. Like Greg keeps saying, what is the rule? So when you understand the difference between judicial and administrative, that's one less thing you're able to sit to the side and focus more in on your administrative case, because people tie those two things in to say one. That's why you keep hearing unconstitutional, blah, blah, blah. But you got to understand administrative operates under the courts, but it has its own guidelines as well.
So should we be trying to appeal an administrative order or vacate it?
If that's not the way to ask me the question.
Okay.
What would Greg do?
Okay, what would Greg do if he had an administrative order versus a judicial order?
If I had an administrative order that I had a disagreement with, then you would have to. I would look at the rule and see that the proper appellate process for a administrative issue is to the District Court of Appeal. If it's in the judicial court, it's the same way, but it's just a little bit different process. Go to Article 5 of the Florida Constitution is where I would go.
And that's for the administrative order.
Or judicial.
Or judicial.
Yep.
Yeah, but a lot of people just, they're tying, they don't know if their case is judicial or administrative. Like me, as an example, I've prepared and submitted documents to the clerk of courts about parenting plans, which that is administrative. I mean, that is judicial. Whereas the only thing that I'm able to submit based on my case being administrative is modification of child support. So child support doesn't want to hear my parenting plan guideline that I try to put. They only focus in on the support order because that's who initially the paperwork was submitted by the mother through the administrative order.
Yeah. Here's how I kind of narrowed it down. Anything related to money, administrative. Anything related to time, time sharing or spousal, I mean alimony and blah blah blah. So that's just like it has to go in front of a judge, right? Because anything administrative related, it's a judge surrogate. So in other words, so a lawyer.
You said surrogate?
Yeah.
I would say this. If the issue is administrative, look up APA, Administrative Procedures Act. Know what that is.
Okay.
If the issue is judicial, it typically will involve already started. It will typically involve a court proceeding. And that's why I keep going by, what was the meritorious determination? We're a little bit longer than we normally are. I had to probably split this thing for people. But what I would say to people is find out the rules for your state. Florida is a judicial state. And even if it's an administrative action, it's subject to judicial review. That's in the Constitution. No, I can't emphasize it any better or any more diligently. You have to learn the rules. As you learn the rules, you will probably be able to ask better questions. Does that make sense? Not to them, but better questions for seeking what your answer may be. It's we did.